So my name is Colin Farnsworth. I am the...
Mr. Farnsworth, I'll give you a full 10 minutes.
Thank you. State Deputy Director for PANDA, Oregon. Been putting a lot of work into getting this passed here at the county level. And the reason that we want to do this at the county level is because we have the authority to do so. Not only is this a very unique topic, because of the, as you can see, all the unconstitutionality of these two provisions, but also we're in a home rule county. I'm going to get into the essay that was written by Ken Tolinaire and Associates in 2005 discussing what home rule is. I'm sure you guys as county commissioners do know a lot about it, but I'm going to get into some of the details for those in the audience and for others listening. The foreword of this document was written by Mike MacArthur, who's the current executive director of the AOC. And it starts out with a little history. 1858 amendment of the Oregon Constitution reserved to the voters of Oregon counties the right to adopt charters prescribing how their county government should be organized, what powers they should have, and what procedures they should follow in administering county affairs. Since 1958, 9 of these Oregon 36 counties have adopted these charters, and this includes Lane County. To go further, this was then expanded by the legislative body of Oregon in 1973, pretty much saying that all counties have this right. However, this statute could be retracted at any point, in which Lane County and these other 9 counties would still have this unless they wanted to adopt the Constitution. So we're extra special, I guess you could say, here in Lane County, and this is why a very strong resolution or ordinance should be passed here. It continues. Here is basically the 9 counties that do have constitutional county home rule. And this does cover actually most of Oregon's population. So if these counties were to follow in your footsteps of passing an ordinance, we could actually protect most of the county's civilians here in Oregon from the NDAA and the wars of law. So that's pretty important. We don't have to wait for the state where that's a lot of gridlock, as well as the U.S. Congress, which is a lot of gridlock there. Or the Supreme Court, which never has to take this point in the first place. Then the most important part of Mike MacArthur's foreword, he says that the U.S. Advisory Commission on Intergovernmental Relations concluded in the 1981 report that Oregon counties have the greater degree of local discretionary authority than counties in any other state. So these counties that are making bills and other ordinances in any other state that are being struck down, well, we sit here in a very unique situation in Lane County where we do have this authority. So what do we do with this authority when we come across some unique, very unconstitutional, radically unconstitutional provisions that we see in the NDAA? Well, on page 51, it discusses some things we could do. Some county ordinances address purely local concerns unrelated to state law, but the bulk of county legislation supplement, amplifies, and otherwise assists in performing duties that state law imposes on counties. Well, one of the state laws that we have here is the state constitution. And we also have the U.S. Constitution that must be enforced in the state of Oregon, and therefore a resolution or ordinance would just amplify here in Lane County those due process protections that are reiterated in the 5th Amendment, the 14th Amendment, as well as in sections of our own state constitution. Finally, on page 19, the other question that would come up is, well, does it fall under matters of county concern? In page 19, it says the matters of county concern is a broad, flexible concept that appears in the county home rule amendment in the state constitution. And so over time, these matters of county concerns change from decade to decade. In the 1970s, they would never think that the NDAA and these 2 illegal sections would take place, and therefore would not be a county concern. But now in the 21st century, as we see more and more things coming down from the federal government that are questionably constitutional, it may be time and place to enact these. And to look at our own Lane County Charter, they realize that the matters of county concern is a variable, and so what they said is they want these powers here to be construed, very liberally. So I'll read Section 2 in the Construction of Powers of Lane County Charter. The charter shall be liberally construed. The county shall have all powers necessary or convenient for the conduct of its affairs, including all powers that counties may assume under the statutes of the state and under the provisions of the state constitution concerning home rule. But there are basically 5 widely accepted matters of county concern, and the one we're going to focus here for our resolution or ordinance that we could potentially pass, or you could potentially pass, is dealing with the police power. And police power on page 47 is defined as such. The police power is far more than law enforcement. It embraces the entire range of governmental actions to preserve, promote the public order, safety, health, morals, and general welfare. And therefore, the creation of community protections against sections 1021, 1022 of the NDAA could easily be defined as matters of county concern. The other question that was brought up by Mr. Kyler here was, well, can police interpose against the federal law? And that is a great question. If you look at the Supreme Court case Prince versus U.S. in 1997, sheriffs in multiple states in multiple counties refused to implement a federal law that they believed was unconstitutional. This went up to the Supreme Court, and the Supreme Court ruled in favor of the county sheriffs to refuse to comply with the federal law. The majority opinion was written by Justice Scalia. He stated that the framers expressly chose a constitution that confers upon Congress the powers to regulate individuals, not states. The great innovation of its design was that our citizens would have two political capacities, one state, one federal, each protected from incursion by the other. The legal system, unprecedented in form and design, establishing two orders of government, each within its own direct relationship, its own privity, and its own mutual rights and obligations to the people who sustain it and who are governed by it. To simplify that majority opinion, basically what he was saying is that by allowing the federal government to draft the police officers of the 50 states into his service would increase the federal government far beyond what the Constitution intended, and this would affect the checks and balances that we would find under dual sovereignty of federalism, which is rarely taught these days. And just to go back to what he was saying, the citizens would have two political capacities, one state and one federal, each protected by the incursion of the other. So when states, similarly in the desegregation of the South, they were in the wrong because they were conflicting with civil rights, and so the federal government was in the right of coming forward and intervening. But similarly in this case, where the federal government is in the wrong and stripping the rights that are expressly written in the constitutions, the people in the states do have a right to intervene, as well as the county under home rule. And to look at the Oregon State Constitution and the text that kind of does support dual sovereignty is the very beginning, the preamble of our own state constitution, which states, all powers inherent in the people and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have at all times the right to alter, reform, or abolish the government in such manner as they think proper. Now, this is not language that would be put in by our drafters of our state constitution, who believe that at any time the federal governments were infringing upon their rights, that they couldn't do anything about it. This was very, they were saying that we do have the right if our powers are ever infringed and our due process is ever infringed, or any other constitutional right. The other part of the state constitution is Article 15, Section 3, and I believe you guys said this right here because you are one of the elected officers. It says any elected officer affirm that they will defend civil rights secured by the constitutions of the United States and the state, and this is what we're asking you to do. The resolution, so, what do we do? The protective procedures. Well, using the county home rule and your oath of office, which is required by the state law, which we would be amplifying with an ordinance or a resolution. It says what we could do is, under the authority of the Commissioner's oath of office and county home rule, they could enact a meaningful resolution or an ordinance that protects the constitutionally guaranteed rights of persons in Lane County against the uses of Sections 1021 and 1022 of the NDAA. And some of these procedures could include, but not limited to, forced reporting of violations by county officials or people, citizens, or residents. Could also include non-compliance of people working in Lane County or from the people, and it could even include prosecution of these of violators. So I do appreciate the time of letting us speak, and I hope something meaningful and effective can come from this public hearing. Thank you.
Thank you, Mr. Collingsworth. Thank you, Ms. Rosman.